Good morning to all of you. Once again, Tart class. In this topic, we are going to discuss the other legal maxim, Damnum Sine Injuria or Damnum Sine Injuria. There is a damage, but without legal injury. Legal injury is not done, then however amount of damage you get, sir, the court will not say. Court will say, Are Baba, this is not a tort. So, damnum sine injuria, damage without any legal injury, it is not at all a tort. So, you cannot get any claim any damages or unliquidated damages. You cannot get any compensation. Why? Because it's not a tort. Because no legal injury was done. This is important. So, damnum sine injuria, damage without infringement of the legal right. Like there may be some monetary loss, there may be loss of comfort, there may be loss of health, there may be loss of services, but still it is not a tort. If you go through the case laws, it will be better for you to understand. So the first very famous case law is Gloucester Grammar School 1410. Yes, 1410. So in the case of this Gloucester Grammar School, it is happening quite even nowadays also. So there was a teacher in the school. He was appointed by the principal. The school ran very well, but there were differences between the teacher and the principal, due to which the teacher got himself separated, went out, and he took permission from the local education authorities and started another school quite opposite to the school of our principal. Gloucester Grammar School. So the teacher who worked there, he has gone out and he has started another institution nearby the area only. Of course, the students, they go to him. The students, some of them joined, and even though our Gloucester Grammar School principal reduced the fee structure, but still the number of admissions there was heavy. Ultimately, he suffered monetary loss. Therefore, he brought an action suit. He brought a case against the teacher, saying that he worked under me, now he has cheated me, he has gone out, he has started another school, and even though I am reducing my school fee, people are not joining, he is doing some activities, all these things. He has filed a case. But court said, so it's not correct, because anybody can run an institution provided he takes permission from the education authorities. There is no guarantee, there is no rule that only one school should be there at a particular place. So we can't help. There is no legal injury. Legally, he is quite correct. He is not wrong, because he has procured a site, he has taken permission, he has started a school. So if he is lucky, so many people joined. Otherwise, same case. So Kabati, there is no legal injury. No doubt, he might have suffered so much of monetary loss. We can't help. So moreover, it was the student's choice to join the institution. So compensation is no ground of action. The suit could not lie. It is not a case of tort. I hope you understood it. Second case, Mughal Steamship&Co versus Mc Gregor, gow&co, 1892. So you know, British are famous for divide and rule. So actually, Mughal Steamship Co, they were the very important, or they have become very popular, and they are the dominant people in the field of loading and unloading in Calcutta port. So once you get the dominance, normally you increase the tariff. So they have increased the rates. Of course, the British people, Mc Gregor and gow&co, they have also come to India. Actually, there was a civil conspiracy. They have met all the agents, loading and unloading agents. Actually, what they stated is they have reduced the freight charges. Suppose Mughal steamship is collecting 25 rupees. They said they will do it for 20 rupees itself. Then where will the stevedores go? Where will the people go? Definitely for the people who supply at a lesser rate. Why are you going to DMart? Only for the, because you are getting it at a lesser rate. So all the people flocked near Mc Gregor & Co, and the Mughal Steamship Company, which was the dominant company till that time, they have suffered loss. They could not survive. Though they said these people conspired and these people have caused loss to our business. The court said, House of Lords, defendant is not liable because defendant did not do any unlawful act. He has reduced the tariff. It is system. మనకి ఇండియాలో రిలయన్స్ కంపెనీ వాళ్ళు అలాగే ఫ్రీగా ఇచ్చారు, తర్వాత వసూలు చేశారు అనుకోండి వేరే సంగతి. Yes, it is a choice. It is the choice of the customer. Customer can go anywhere. We cannot do anything. So it's not a legal injury. Okay, damage is there definitely, but not when it is not done legally. We can't help. It is not a case of tort. Then third example is Town Area Committee versus Prabhu Dayal. This is 1975. This is a negative example. Please remember, negative examples also we have to take into consideration. So actually, our friend has constructed a house without taking permission from without obtaining proper permission from the town area committee. That means from the municipality, he did not take up the permission. So you can't go for illegal constructions. No doubt, in Ongole, for that part, in so many areas, we will be seeing so many illegal constructions. But as per law, you cannot construct a building illegally. That means without municipal corporation's permission. So immediately, the town area committee, they have given a notice to him. Arey Baba, you have constructed the building without this. Either you get it regularized or do something, they have given a notice. But there is no response from him. Ultimately, on one fine day, they came and demolished the building, for example. Then he said, I was put to so much of loss by the municipality. So please pay the compensation. It is a case of tort. But court said, you yourself are the wrongdoer. You have not followed the guidelines given by the municipality. You have not taken permission from the municipality. When you yourself are a wrongdoer, then there is no legal injury. So there is no damage is there. No doubt your house is damaged. We agree. We pity you. But legally, we can't do anything. Because the plaintiff, that is Town Area Committee, they were able to prove that the defendant violated the municipal rules. Court held it Damnum, Sine, Injuria. So, no liability. Another case, Bradford Municipality. It is Mayor and Co. of Bradford versus Pickles, 1895. So, actually, the Municipal Corporation of Bradford, they were supplying water to the individuals from the well located at a distant place. They are drawing water from there because potable water or drinking water will be available only at a particular place, not in the entire town. So they are drinking it from the well. So actually, the defendant, that Mr. Pickles, he wanted to sell his property to the corporation. పక్కనే ఇతని స్థలం కూడా ఉంది, ఆ నీళ్ళ బావి దగ్గర పక్కనే ఉంది కాబట్టి నాది కూడా కొనుక్కోండి. ఆఫర్డ్ టు ద మున్సిపాలిటీ, బట్ మున్సిపాలిటీ సంగతి మనకు తెలిసిందే కదా, దే విల్ గో బై సర్టన్ రూల్స్. ఎంత డబ్బులు అంటే వీడు కోపం వచ్చింది, డీల్ సెటిల్ కాల. అల్టిమేట్లీ ద డిఫెండెంట్ స్టార్టెడ్ ఏ వెల్ ఆన్ హిజ్ ప్రాపర్టీ టు డైవర్ట్ ద వాటర్ సప్లై టు. సో ఈయన కూడా వాళ్ళని చూసి తను కూడా ఒక వెల్ తవ్వించుకొని, ఎందుకంటే తనకు నీళ్ళ కోసం సపరేట్గా తవ్వించుకున్నాడు. కానీ ప్లీజ్ రిమెంబర్, డ్యూరింగ్ దిస్ ప్రాసెస్ ది వాటర్ సప్లై ఆఫ్ ది కార్పొరేషన్స్ వెల్, అక్కడ ఉండేటువంటి వాటర్ సప్లై కట్ ఆఫ్ అయిపోయింది. సో దీనివల్ల ఇట్ వాజ్ ఎ లార్జ్ లాస్ టు ది కార్పొరేషన్. నౌ వెదర్ దిస్ మ్యాన్ ఈజ్ లయబుల్ టు పే కాంపెన్సేషన్ ఆర్ నాట్, కోర్ట్ సెడ్ నో, బికాస్ there is no malice in law, there is no intention. No, we cannot prove the intention also. ఎందుకంటే తన స్థలంలో తను బావి కట్టుకున్నాడు, ఈ కనెక్షన్ కట్ అవుతుందని అతనికి తెలియదు, కనెక్షన్ వీళ్ళు అక్కడ దాకా ఎక్స్టెండ్ అయింది, మున్సిపాలిటీ తప్పు కాబట్టి ఇట్స్ నాట్ ఎ కేస్ ఆఫ్ టాట్. సో ప్లీజ్ రిమెంబర్, ద కోర్ట్ హెల్డ్ దట్ డిఫెండెంట్ వాజ్ నాట్ లయబుల్ టు పే కాంపెన్సేషన్ బికాస్ ద లీగల్ రైట్స్ ఆఫ్ ద ప్లెయింటిఫ్ వర్ నాట్ ఎట్ ఆల్ వైలేటెడ్. నో డౌట్ వాడు ఖచ్చితంగా కావాలని చేసి ఉంటాడు, బట్ స్టిల్ మ్యాలిస్ ఇన్ లా లీగల్గా ప్రూవ్ అవుతే మనం ఏం చేయలేం. సో కాబట్టి దిస్ ఇస్ ఆల్సో అనదర్ ఎగ్జాంపుల్ ఫర్ డామ్నమ్ సినే ఇంజూరియా. సో ప్లీజ్ know both the principles, because you are in the baseline. So you have to decide whether it is a case of tort or not. Unless you know these two mechanisms, it will be difficult for you. So please study the notes, prepare well, and we'll discuss tomorrow in the next class. With this, I am concluding. Thank you very much.